another unanimous ruling from the Supreme Court.
We have breaking news. The Supreme Court has made a decision on the first major Second Amendment case in decades.
Major ruling involving the Second Amendment.
The Supreme Court has just issued a major ruling.
Major Supreme Court ruling.
Now, this is the most significant Second Amendment ruling in more than a decade.
It's a case that legal experts will be watching closely when it likely heads before the justices.
The Supreme Court will be taking up a gun rights case.
Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
In the span of just one court session, your fundamental right to keep firearms in your own home could be stripped away forever. Not through new legislation, not through executive orders, through a single Supreme Court decision that could redefine the Fourth Amendment and obliterate protections that have stood for centuries. And here's what makes this absolutely terrifying from a constitutional perspective. Most gun owners have no idea it's happening. Their attention is focused on traditional threats like assault weapon bans and magazine restrictions, while the real danger approaches through an invisible legal corridor they don't know exists. This isn't just another court case. It's a masterclass in constitutional erosion so sophisticated that even seasoned legal experts are struggling to grasp its full implications. Two legal doctrines, centuries apart in origin, converging with such precision that they could dismantle your home security forever. One established that police cannot simply walk into your home and seize your guns under vague caretaking roles. The other now threatens to create exceptions so broad that the original protection becomes meaningless. Both cases succeed because they don't fight the battle gun rights advocates are prepared for. They create an entirely different legal battlefield, one where emergency exceptions, officer discretion, and public safety concerns matter more than constitutional protections. What's unfolding represents a watershed moment in American jurisprudence, the kind of precedent that gets referenced in constitutional law for generations, and the details are absolutely jaw-dropping.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
Justices ruling this morning it conflicts with the Second Amendment's right to bear arms.
Loophole that police are using to get inside your home without a warrant. But a unanimous Supreme Court ruling gives you the power to stop them.
The United States Supreme Court came out with a unanimous ruling in Caniglia versus Strom.
Caniglia actually raised something known as the community caretaking exception.
Constitutional protections of your home are absolute.
During an argument with his wife, Edward Caniglia retrieved a handgun from his bedroom, put it on the dining room table, and asked his wife to shoot him now and get it over with.
The unanimous victory that changed everything. In 2021, the Supreme Court's chambers witnessed something extraordinary. 9 justices speaking with one voice to protect your home from government intrusion. The case was Caniglia versus Strom, and it looked like any other Fourth Amendment dispute involving police overreach and firearm seizure. Law enforcement had every procedural advantage. They claimed community caretaking authority. They cited public safety concerns. They argued that welfare checks justified warrantless entry and gun confiscation. The justices shouldn't have been impressed, because what looked like a routine police powers case was about to become the most important gun rights decision in decades. The court's analysis began not with firearms law, but with something far more fundamental: the sanctity of the American home. Edward Caniglia had argued with his wife about a handgun. She left for the night and called police the next morning, concerned about his mental state. Officers arrived, convinced him to go for a psychological evaluation, then entered his home without a warrant and seized his firearms. To police, this seemed like reasonable community caretaking. To the Supreme Court, it was constitutional violation of the highest order.
As we all know, that searches require, under the Fourth Amendment, a warrant.
A case where the court was asked to decide if the same warrant exception that applies to impounded vehicles applies to homes.
Something that hasn't been used a lot, and the court had to address whether it can be used at all when it involves a home.
When protection becomes precedent. The beauty of the Caniglia decision wasn't in its complexity, it was in its absolute clarity. Writing for a unanimous court, Justice Clarence Thomas demolished the government's arguments with surgical precision. The community caretaking exception, he explained, applied only to vehicles and public spaces, never to the home itself. While lower courts had been gradually expanding police authority through vague emergency doctrines, the Supreme Court slammed the door shut. The Fourth Amendment's protection of houses was categorical and non-negotiable. No welfare check, no matter how well-intentioned, could justify warrantless entry and firearm seizure. Here's where the decision became ingenious. Instead of limiting its scope to guns, the court created a fortress around the entire concept of home privacy. Every protection worked in concert with the others. Warrant requirements remained absolute. Emergency exceptions required traditional probable cause standards. Officer discretion could not override constitutional protections. In under 30 pages, the tactical balance swung completely from government authority to individual rights, transforming police caretaking powers from a growing threat into a constitutionally neutered doctrine that couldn't breach the walls of your home.
The Supreme Court is set to hear oral arguments in a case that could impact what's needed for law enforcement to enter your home without a search warrant.
Officers need that some sort of emergency is afoot before they can enter into somebody's house without a warrant.
And it's a case that could redefine what's needed for police to enter your home without a search warrant.
That's where the state of Montana comes in, saying setting a higher threshold in an emergency could mean life or death. What's it take for an officer to determine there's an emergency and then enter into your home without a search warrant?
A constitutional standard for police behavior throughout the entire United States.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
The exception that threatens everything. But an even more dangerous challenge was already forming in Montana's legal system. At 2:17 in the morning, police received a call about erratic behavior at a residential address. 4 officers arrived to find a man inside his own home with what appeared to be a handgun visible. They spent 40 minutes outside, then entered through an unlocked door without a warrant, claiming emergency aid authority. This was the opening move in a legal strategy designed to circumvent everything Caniglia had established. The case became known as Case versus Montana, and it began not with direct constitutional challenges, but with elaborate legal maneuvering. Montana's Supreme Court ruled that emergency aid doctrine allowed warrantless entry based on something less than probable cause, mere objective reasonableness. While legal observers focused on the immediate facts, the real operation proceeded through constitutional interpretation. The Montana court essentially argued that emergency situations created exceptions to warrant requirements, even in the home, when officers reasonably believed someone might be in danger. The ground game against your rights. Along every constitutional boundary, new legal theories crept through established precedent, undermining traditional Fourth Amendment protections with emergency exceptions and public safety arguments. Simultaneously, in courts across America, similar cases maneuvered into position, each testing different aspects of the warrant requirement. With Caniglia's protections established but emergency aid doctrines proliferating, the ground shifted toward a fundamental question. Could police enter your home without a warrant if they claim to be helping rather than investigating? This wasn't theoretical legal sparring. As officers engaged traditional constitutional protections, drawing their focus, a more dangerous doctrine slipped through judicial reasoning that most gun owners never saw coming. The Montana decision had breached the constitutional framework, planted legal precedents, and neutralized Caniglia's protections, all before Second Amendment advocates realized what was happening. The legal battle nobody anticipated. Now the Supreme Court faces a choice that will reshape American liberty with breathtaking consequences. The justices must decide whether emergency aid exceptions can override warrant requirements in the home, potentially creating gaps in constitutional protection large enough to drive a police cruiser through. Case versus Montana represents something unprecedented in modern constitutional law, a direct challenge to the home's protected status using public safety language that sounds reasonable but carries devastating implications. If the court accepts Montana's reasoning, the precedent could allow law enforcement to justify home entries whenever they claim emergency circumstances exist. This creates a constitutional breach through which decades of Fourth Amendment erosion could flow. Through this gap, red flag laws could expand. Welfare checks could multiply. Emergency exceptions could swallow the warrant requirement entirely. The final strike against constitutional protection. The ultimate question executes with surgical precision. Can your home remain a constitutional fortress when emergencies become the universal key? The Supreme Court's decision will determine whether Caniglia's unanimous protection meant anything at all, or whether it was simply the first move in a longer game to eliminate practical privacy rights. Every constitutional protection hangs in the balance. If the court rules that emergency aid justifies warrantless entry, the Fourth Amendment's home protections collapse into a permission slip that police can override whenever they claim good intentions. The stakes couldn't be higher. Gun owners who legally store firearms could face seizure during any wellness check. Families could lose privacy rights whenever neighbors report unusual behavior. The home could transform from a constitutional sanctuary into just another place where police authority supersedes individual rights. Your rights hang in the balance. What began as Caniglia versus Strom, a unanimous declaration that government caretaking ends at your front door, now faces Case versus Montana, a challenge designed to create exceptions so broad that constitutional protections become meaningless. This represents more than legal technicalities. It's the difference between living as a free citizen in your own home and existing as a subject whose privacy depends on government approval. The Supreme Court will soon decide whether your Fourth Amendment rights remain absolute or become conditional on police assessment of emergency circumstances. Whether your firearms stay protected by constitutional barriers or become vulnerable to seizure whenever officers claim public safety concerns. Whether your home remains your castle or becomes another place where government authority takes precedence over individual liberty. This is where constitutional protection meets practical reality. The court's decision will define whether Americans retain meaningful privacy rights or whether those rights dissolve whenever officials invoke emergency language. Your freedom to live securely in your own home with your legally owned firearms protected by constitutional guarantees that cannot be overridden by good intentions or public safety claims. All of it depends on how 9 justices interpret the balance between individual rights and government power. The next chapter of American liberty is being written in legal briefs and oral arguments. Make sure your voice becomes part of that conversation before the final decision renders it irrelevant.